okay, when do we motion the court to separate cases, counts, co-defendants? It's pretty straightforward, actually, and it really increases your likelihood of success when you do it. My name's William Moore. I'm with W.R. Moore Criminal Defense, and basically, in a nutshell, when it comes to separating criminal counts and cases, you want to just remember the few scenarios, and you're going to sense the benefit in filing a motion to sever when the situations arise. But I wanted to point it out because I see people missing this stuff, and I primarily see it with the enhancement crimes. When it became a criminal act to refuse chemical testing for a second time, and this is in DUI investigations. These cases they're still commonplace, but they were rolling in and out of the county courts, and they stayed together. Lawyers were trying these things together. Nobody was really thinking about it. And basically, you've got a DUI and then an accompanying charge that says, hey, I've been under suspicion of DUI in the past. Well, you got to separate those. But let's go from the beginning here, where a criminal count requires the prosecutor to prove a prior conviction. Well, in the example I just mentioned, the prosecutor doesn't have to prove a prior conviction. It's a prior refusal, but that's still a prior bad act, and that's not allowed under the Florida Evidence Code. So you got to separate those things. You got to move to sever where a co-defendant's defense or prosecution will prejudice your client. Well, certainly. If statements are going to come in, anything tantamount to co-conspirator statements, anything that can be used is going to affect your client, or otherwise shouldn't have come in if your client was trying the case alone. That's all you need. Move to sever. Move to sever where multiple criminal counts are brought under one action despite feeling or seeming unrelated, whether by time or the facts and circumstances taken as a whole or separately. Always move to sever. Never, ever entertain the thought that you are making more trials for yourself, regardless of how many counts, actions, or co-defendants you split up. Never, ever consider the added time or work, because you're going to win if you separate this stuff, and you run a risk of losing if you don't. Where time frames of the parties are opposed to one another, and it has the negative effect of your client exercising their right to speedy trial, whether they're going to or not. Separate your co-defendants. Of course, where proposed jury instructions conflict, and I've got a neat section on this coming out next week, so definitely look for it. Where one of the parties was direct filed, and I'm sure all of you know what direct filed means. You've got a juvenile in the courtroom with adults being tried. Where both parties to a drug trafficking case were denied an opportunity to provide substantial assistance, where neither one of them got the magic words that was going to bring down the minimum mandatory, the only saving grace. Both have been declined an opportunity. You pull your client out of there. My name's William Moore.